him, he goes up, he says he knocks on the front door 20 or 30 times, rings the doorbell 20 or 30 times, nobody comes to the door. So he walks back, he had pulled his police car up the driveway to the house. So he's walking back across the front of the house towards the police car, and on the end of the house, there is a walk-in door, a door that goes into the garage, not the garage door that the car can pull, just a walk-through door. And he sees this door is slightly ajar, and he says, you know, this door was not ajar when I got here. Because that's what he testified to in deposition later. He walks into the garage, shines a flashlight around. Now it's a messy garage, like a garage that people use for storage, not for cars. Nothing else out of the ordinary. He turns around and he leaves. He backs his car out of the driveway. Now, these cars that the neighbor had been talking about coming and going, there were 3 cars parked by the street. And this is a neighborhood without sidewalks. It's just the edge of the road, then a small shoulder, then grass. These cars are parked halfway on the roadway, halfway on the grass. Sergeant Wood, in his infinite wisdom, calls in the license plates to these 3 cars to his dispatch center and says, call the owners and tell them if they don't come pick up their cars, they're going to be towed. Claiming that the vehicles are obstructing traffic at 1 o'clock in the morning in a residential neighborhood in the Reed Mountain area of Botetourt County. At deposition, he testified that one of the cars was parked at an angle where the rear end was sticking out into the roadway and created a slight hazard. The other 2 cars, well, you know, one side of the wheels was on the roadway, one side of the wheels was on the grass, but they weren't really obstructing traffic. And even with the car that was at an angle, cars could still go by. He was able to drive his own squad car by. What he knew, though, was, and see, Sergeant Wood's not stupid. I think he kind of figured out that there are probably some teenagers in the house, they're at an underage party, they're just not going to answer the door, and the police will go away. But if I call the owners of these cars, well, the cars are probably registered to the parents. If I call the parents, I'll get the parents all upset, and maybe these kids will get in trouble. Maybe the parents will come and knock on the door. Maybe the parents will go busting into the house and find their kids, and maybe I can get into the house that way. What happens is the first parent that is called says, well, yeah, my stepdaughter was driving that car, but she's supposed to be staying with a friend tonight over in the Rainbow Forest area of the county. And this father becomes very upset, and he begins calling his stepdaughter's cell phone, and she won't answer. Because the stepdaughter's hiding in the basement because she knows the police are there, and she's been drinking, possibly among other things. He rushes over to the house with the address they had given him. Said, yes, that's my daughter's car. I don't know where she is, don't know what's going on. And Officer Wood says, let's go up to the house and see if we can get anybody to come to the front door. Although he has supposedly already knocked on the door and rang the doorbell 20 or 30 times. He now testifies that as he is going up to the house and walking across the path in front of the house, he hears a noise in the garage. At that point, he and the stepfather run into the garage. They see and hear nothing else, yet they proceed to search the entire house, basement, first floor, upstairs, purportedly searching for this man's daughter who is missing. They find a 10-year-old girl sleeping in her bedroom. They find the owners of the house asleep in their bedroom, and they professedly apologize for what they've done and say, well, we're just looking for this man's daughter. Now, they did not find the 3 juveniles hiding in the basement behind the hot water heater. They are chased out of the house, and the homeowners have the wherewithal to call 911 and report a burglary by Sergeant Wood and an unidentified male. Lieutenant Blesser then comes on the scene, takes a complaint. A complaint is forwarded on to the sheriff of Botetourt County, who never responds. Doesn't say a word, never calls up the family, never says, you know, this is an unfortunate thing. I think my officer did the right thing, but you know, I understand why you're upset, or we're just sorry it happened. So, that family comes to us, and we file a lawsuit, more because the parents are upset and annoyed by the fact that the sheriff never called them, and apparently thinks that it's no big deal that a deputy just went in and searched the house top to bottom without a warrant. Now, of course, you get into the whole issue of whether it was a reasonable search of the home, whether the officer had probable cause to go in and search the house. But really, that didn't become an issue when we got into the litigation phase. The whole case turned on whether or not the officer was in a safety or prevention mode. He was, searching for this 17-year-old girl who wouldn't answer her cell phone at 1 o'clock in the morning because she was somewhere she shouldn't be, not at the house where she was supposed to be, and drinking beer and hanging out with boys on a Friday night. Now, other than a car that she had been driving earlier that night being parked in front of the house, there was no reason to think that she was at that house. Now, the courts apparently thought that was enough to let the officer go in and search the house. I won at the district court level in front of Judge Wilson. The Fourth Circuit took it away. The Fourth Circuit said that was a reasonable search of the house. Now, I think what was really going on in Sergeant Wood's mind, he knew that party was going on, and he was going to get in there somehow. He was going to find the beer, find the juveniles, charge a bunch of kids with Class 1 misdemeanors for underage drinking, because he had a reputation around Botetourt County for that. In fact, the boys who lived in that house knew this deputy. They didn't know what his name was, but they knew this guy shows up at the teen parties. This guy's the one that busts the parties around the county. He would show up, and he'll give everybody a little breath test, and if you blow positive, you get a ticket. If you don't, you get to go home, so on and so forth. In fact, one of the boys at this house said, the last time I was at a party and Sergeant Wood showed up, Sergeant Wood would have everybody, okay, if you haven't been drinking, get in that line. If you've been drinking, get in that line. He said, I hadn't been drinking, but I got in the drinking line just to play with him. And I got up there and I blew it. It was a 0. The officer looked at me and he said, next time I'm going to get you. So there's some indication that Sergeant Wood might have even known whose house this was and targeted this family once he figured out because the last name was not a common name. The last name was Hunsberger. Not a lot of Hunsbergers, I'm guessing, in Botetourt County. But I was extremely taken aback that the courts in Virginia, the federal courts at that, would say an officer can go in and search a home based just upon those facts. All for safety's sake. So, if it had been my house, safety's sake would have said, I probably would have been meeting that deputy with a gun and somebody could have been shot. These homeowners didn't own a gun. It's just not their thing. But that is just yet another example of how difficult it is to litigate civil rights lawsuits. I believe that the police overstep their bounds. I also believe that most of the time, police do their job the right way. Most of the time. I also believe that I, as an attorney who practices civil rights cases, have an obligation and responsibility to help hold the police in check. Because they shouldn't want their fellow officers violating the Constitution any more than I do. It gives them a bad name, gives them a bad reputation, makes everybody look bad, and then you have things like happened with Sheriff June11 last week with his deputy, who he's trying to protect, shooting and killing his wife in the Sheetz parking lot, and then leading state troopers on a high-speed chase and trying to commit murder or a suicide by cop. And he wasn't willing to call and put out an all-points bulletin. He'd rather take care of it himself. And it further just diminishes the idea of men who carry a badge, women who present a badge of authority. Because I think most of them do the right thing. But when I think they've overstepped their bounds, I'm more than willing and happy to pursue litigation and hold them accountable when I think the circumstances warrant it. So that's a lot of what I do. I spent the day today finishing off a response to a motion against Sheriff June11 in another case. One of his deputies shot and killed a guy last year in July, and we've sued the deputy and the sheriff specifically for inadequate training of his deputy and how to handle domestic situations. This involves the parents of a 40-year-old man. He was in a domestic altercation with his girlfriend at her house. The parents had called the police multiple times during the day. Please send a deputy to the house. Let a deputy go with us to the house so we can remove one of the parties from the altercation, just to defuse the situation. They knew that the girlfriend had a concealed weapon permit, owned a gun. The sheriff's office told her on Well, unless somebody from the house calls, we can't go up there. Got to be somebody from the house that calls and wants police assistance. We can't do it because you're not at the house. They even went to the sheriff's office and talked to a dispatcher and said, please, please, there's a gun. They've been fighting all day. They're probably drinking. They might have been doing drugs. Somebody could really get hurt. I'm sorry, man, can't help you. Unless somebody calls from the house, we can't do anything about it. They finally go. Here's when the police finally go to the house. The girlfriend had a friend come and pick her up, and she went to the liquor store and to McDonald's, got a double cheeseburger, and comes back to the house. When the friend drops her off at the house, the friend is backing up her car to turn around and leave, and the guy comes out of the house and fires the gun, we think, in the direction of the car. And this lady calls 911 and says, my car has just been shot at by this guy. These people have been arguing all day. No, I don't want charges filed against the guy for shooting in an occupied vehicle. I just want somebody to go check on him. Finally then, and by this time it's 4:45 in the afternoon, and this guy's parents have been calling since about 11 o'clock in the morning. So like 5-6 hours later. Finally a deputy shows up. He gets in an altercation with the guy, gun on gun. Yeah, my guy's got a gun. The deputy's got a gun. My guy fires one shot into the ceiling, and the deputy shoots him 8 times. Maybe if you fire a gun in the presence of a police officer, he's got a right to shoot you. I don't know. That's what the law will have to determine for us. But I know, because I've got the report from the Virginia State Police. My guy has the gun and shoots it probably about like this. Into the ceiling, probably about 6 feet away from his person. The deputy's over here. His girlfriend is right here. But as soon as that gun goes off, there's about a second hesitation, and then you hear the officer fire off. Pow, 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 pow. Shoots 8 times. Or at least that's how many rounds are accounted for. 8 rounds of 13 rounds he had in his firearm. He's dead. He's gone. No question about it. But we filed a wrongful death lawsuit. I hesitate to say this on camera about what I think the chances are of success in that case, given the courts where we litigate. And I can sympathize to some degree with somebody saying, you know what, if you fire a gun when a deputy's got a gun pointed at you, you ought to expect to get shot. It's just not a smart thing to do, regardless of what the Constitution says about, reasonable apprehension and such like that. Because this case will most likely be analyzed under a Fourth Amendment unreasonable seizure standard. And the reasonable standard is a reasonable officer in that officer's position, would he have done what this officer did? That's the standard I'm dealing with. An objective, reasonable standard. Not hard for an officer to satisfy. Like I said at the beginning, officers get the benefit of the doubt. They get to second guess, we don't. And there's a lot of deference toward them and their decisions. That's where we are. I would be glad to answer any questions you have, talk to you more about it, and see where we can go with it. Yes, sir.
Yes, I know everybody doesn't know other people's feelings, but I know how you are going to process this. How are we going to fix it?
How are we going to fix it?
Everybody talks about the tax communities. You defend the company. In one case, the police said, I can right to go into the house. And in the other case, he said, the police should have gone into the house. Fairly.
Right.
So, it's tough to talk to the good side of it, and the whole system is like,
Yeah. I think it's very fact specific. Very fact specific. In the one case where I think the police should have gotten there sooner, should have gotten where the parents are complaining and it ends up in a shooting, you had a report of ongoing violence in the home. The other case, I've got a quiet house with a nosy neighbor complaining about kids coming and going. And I think it is a distinction. It's worth